Okay, good afternoon, everybody. I'm based in Berlin. My name is Robbie Morrison, and I'm going to talk about licenses, specifically open data licenses and open source software licenses. Now, we had some discussions at the beginning of this, while we were organizing the event, and it was decided it was probably better if the presenter gave a presentation at the beginning, and then that would give some context for a discussion. But I really encourage people to chip in, and particularly via video rather than the chat system. I'm going to have trouble keeping up with everything. So without further ado, let's start. Hang on. Now, I just want to make an opening remark that my generation has left our planet in a terrible state. And Nicholas Stern was quoted in the Guardian newspaper this morning saying that economists had grossly undervalued young lives. Well, that's one way of putting it. The photograph here is the first Fridays for Future school strike in Berlin, and I went down and covered that as a citizen journalist and interviewed Louisa Neubauer. Some of you will know the name. I think that was her first interview. And so these kids were pretty young who were striking for their future. So full marks to them. This slide covers some background, and I won't go through it in detail, but I started energy system modeling in 1995, high resolution nation-based energy system modeling, which was pretty rare in those days. And I added an open license to the Decode code base in 2003 and attempted to build a user and developer community. And that really represents the first open energy system model that intentionally was open licensed and set out to develop a community. I was a maintainer for 7 years, and for various reasons that project became stranded. There were a couple of other things on there, but the one I want to pick out is that I participated in the Free Software Foundation Europe legal network community for about 4 years now. And that's my main contact with open source lawyers and technologists. And that's a fascinating community to be in. And a lot of my ideas have been formed participating and watching that community. That's my abstract, which I'll skip. In terms of orientation, I'd just like to talk about the fact that I'm talking here about the legal aspects of open code and open data. And the main message, and I'm sorry to say, is that the legal context for open data is a complete shambles. And that licensing, in a sense, is just the tip of the iceberg of concerning data governance, data provenance, sorry. And these are issues that we need to address. Sorry, I'm just having to admit people. As a community, when I say as a community, I mean the open energy system modeling community. The context here is European Union law. When I say software and code, I mean open source software for public interest analysis. And when I say data, I mean non-personal open data, which can be or has been made public legitimately. So that takes all the privacy issues off the table concerning the GDPR. And I will not be covering proprietary licenses. Oops. So just to recap, so software for public interest analysis only. And I've heard all the reasons why you shouldn't open source your energy system model. The code is too messy, there's no documentation, there is no overhead for servicing inquiries and so forth. Now, all those excuses have largely faded in the time that I've been involved. And some of the people who provided that information to me have now become some of the strongest advocates for open source software and open modeling. Open source is also the dominant software development model, and estimates of up to 90% for new projects. Part of that is because software is now a service through cloud delivery, and less a commodity that is sold. So that's part of the reason for that that shift. Again, we had a little bit of discussion earlier today about the use of personal data. This discussion is completely limited to non-personal data, or data that has been anonymized and cannot be used to identify a person. In addition, there's a data tsunami, as most people will be aware, that has been enabled by hardware development and internet technologies. And I just want to point out that the interest in openness is driven equally by transparency and opportunity. On one hand, we've heard that open energy system models are useful for third-party confirmation, but they're equally driven by the need for collaborative development. And I will just mention 4 projects here, and I'm trying to be even-handed, but EMP-E, Pipes, Calliope, and Osmosis are some of the leading open source projects in the European space. I just would like to say that, for example, EMP has 50 people at their developer meetings, and I don't believe that any of the non-open projects can meet that kind of interest. To provide some context, open science is also gaining ground, and here's a little chart showing some aspects of open science. Our corner of the world is mostly concerned with open source software, open data, and open access publication. There are several development paradigms, as I see it, governing energy system models that provide public interest analysis. And on the left-hand side of the slide, we see single institution closed models, of which there are quite a few. Freeware products, of which Energy Plan is one, and we heard about that this morning. Consortium development, and you could look at models like Times for that in that context. And then the raft of open source projects, which I mentioned, 4 particular ones. The key issues are open development, transparency, and community. And that's really useful. I'm just admitting people, so sorry. I want to talk about the type of information that energy system modelers deal with that other areas might not. And that's what the Commission calls privately held information of public interest. Some disciplines can generate their own primary data as they need, and I would probably cite the climate modelers in this regard. But energy system analysts are highly reliant on privately held information. Later on, I'm going to talk about problematic information under statutory reporting, 2 examples which are not open license, and that's the ENSO-E Transparency Platform database and mandated public disclosures by the EEX, the European Energy Exchange. Just to digress a little, the community I am most strongly associated with is the Open Energy Modelling Initiative, also known as the Open Mod, which began in Berlin in September 2014 in a 2-day meeting with 28 attendees. They produced a manifesto, but one of the more interesting things, in my view, was that our Berlin open source lawyer, Till Jaeger, spoke at that first meeting, and Till Jaeger along with a colleague, has written the definitive book on open source software law in the German context. It's quoted at the bottom of the slide in its 5th edition. So I think that's really quite interesting that the legal context was there from the very beginning of the open mod. Just to comment, the open mod does not endorse projects or take specific positions. Anything I say is in the context of this presentation are my own views. But just to give you an idea of how large the community is, 190 attended the last physical meeting before COVID-19. There are 800 accounts on our discussion forum and 900 participants on our mailing list. Still a digression. There was a manifesto, and here's a little diagram dated 2014 showing the progression of workflow from open data through open source models through into model outputs and interpretation, with a number of aspects: community, quality, efficiency, insights, and information sharing. So these are all key issues within the community. Let's track back to licensing. Licenses are used in this context to allow users to do things with copyrighted material or otherwise protected material that they might not otherwise be able to do under law. The software licenses also deal with patents. And the data licenses also deal with database rights, which we'll come to. Copyright licenses, in a sense, come down into proprietary licenses, which we're not going to talk about, and public licenses, which apply to any and all persons. Public licenses further break down into open licenses, which allow a greater degree of freedom and scope. And these licenses are approved by so-called license stewards. For open source software, one license steward is the Open Source Initiative, and for data licenses, it's the Open Knowledge Foundation. So there at the bottom, we have open source licenses and open data licenses, and that's where we're headed. I just want to point out that the licensing split I've just shown you arises from the way the law is framed, but it doesn't work very well. And particularly for artificial intelligence applications, that split between code and data is indeed fuzzy. And there is currently academic research on the need for hybrid licenses that will work in an AI application. I also argue that for energy system models, that split is also not crystal clear, and code bases often embed hard-coded data. So licensing, public licenses and the subset open licenses are one instrument, the key instrument that we're talking about here, whether it's for code or for data. But I want to mention two allied instruments that are also used. One is called the contributor agreement, which applies to software projects, but is not widely used. And that gives the project itself greater rights over the contributions that contributors make. I don't really want to talk about them very much, but I think they're worth mentioning in the legal context. Another allied instrument is the so-called Developer Certificate of Origin, which the Linux Foundation develops to affirm that a contributor is legally able to submit code contributions if they work for a corporate. So that may have some role here, I don't know, but they're not used within this domain to my knowledge. Licenses are quite varied, and the Linux Foundation has overseen the so-called SPDX project, which provides identifiers. And I've listed some down the bottom here. They are standard identifiers, and people use them. For example, the Creative Commons CC BY 4.0 is the standard abbreviation for that particular Creative Commons attribution license, version 4. And so we'll look at some of the other ones a little later on. I said I put in a couple of quizzes. How many entries in the full version of the SPDX license list of public licenses are there? And I won't give you a chance to respond, but the answer is 17,000. There are a lot of licenses out there, and there are, unfortunately, companies, some of them are very well-meaning, who write their own licenses. Western Power Distribution in the UK was one that I encountered recently. These licenses are problematic because no one knows what their compatibilities are. And I would firmly encourage people to stick with the half dozen common licenses in use. Software licenses come in different grades, if you like. And down one end, we have on the left side, we have the permissive licenses, of which I would recommend the MIT license as being a good choice. And at the other end, the GPL family of licenses, of which I would recommend the AGPL version 3 as being a good choice. And this graph shows, it's a directed graph, shows that how code can be imported into increasingly stronger licenses. Once it has a strong license on it, it can't be ported backwards in the opposite direction unless that project is able to relicense under a weaker license, and that does happen. So which software licenses? And as I said, in the absence of other considerations, either aim high, the AGPL 3.0 or later, and that maintains your code base integrity. It means that it's, in this sense, it stays as a complete item. People don't pick away at it and fork it and you know, water it down, if you like. And the Linux kernel is under a GPL version 2 license, and one of the reasons that Linux is considered to be successful is that it was not forked because of its license. The other strategy is to take a MIT license, and that facilitates third-party uptake, and it means that people can take parts of your code and merge it in with their own code base. And there's some reasons why that's a good strategy. If you license high, you can often relicense low as circums dictate, and Pipesa, one of the more well-known open source energy system models, recently relicensed down to MIT because it suited their needs more readily. So that's a good example, I guess. I want to go through about 5 slides on the core legal concepts, because we're talking primarily intellectual property, but not exclusively, and I'll come to that. So any sufficiently creative and substantial work is automatically protected by copyright, but the thresholds for that protection vary markedly between jurisdictions. It may seem somewhat odd, but our source code is actually considered as a form of literary work. That's where the legal tradition comes from. Other intellectual property rights may apply. In the US, software patents are supported, but that's not the case in the European Union. The European Union did not go down that track. Conversely, the European Union decided to protect databases specifically, irrespective of whether they were creative or not. And this is the so-called 96.9 EC database protection. These protections are not absolute, and in the US you have fair use, And countries with British legal traditions, you have fair dealing, and in continental European countries such as Germany, you have similar considerations, but they tend to be weaker. Public licensing is the method of providing additional permissions to users, to any and all persons, provided those persons abide with the terms and conditions of the license in question. Failure to do so typically results in the license being summarily revoked. We're talking here for both for software, for content, and for data. Conversely, if there is no intellectual property right in the underlying material, then the license notice can be legitimately ignored. In other words, if there is no intellectual property, there is nothing to license, and users can ignore the license if it's provided. The problem here is certainty. It's very difficult for users to know if there are intellectual property rights embedded in the particular work. And our license notices communicate the use rights. Now, in some areas it's not so important, but for a lot of people working in energy system analysis, they are necessarily risk averse. They work for risk averse institutions, and they need to know that their use of intellectual property is actually legitimate and lawful. Having said that, most of the public licensing text, or the open licensing text as a subset, are based on US legal traditions, and how they translate into, say, a European context is a difficult question. I also want to make quite explicit that there is no statutory support for any of this. And in a recent submission to the European Commission on their proposed Data Act, I explicitly suggested that the European Commission look at providing statutory support for open licensing, particularly open data. And the final point on the slide is that very many unanswered legal questions exist, and this uncertainty is very problematic. I want to talk briefly about jurisdictional differences. The governing law for public licenses in the United States is mostly intellectual property rights. In the European Union, it's either intellectual property rights law or contract law. The United States has a strong concept of public domain, which doesn't exist in Europe. It doesn't have a concept of moral rights. That's the right of the creator to be associated with the work and so forth. But most European countries do have a tradition there. The threshold for copyright in the United States is sufficient creativity, ditto for the European Union member states. But in the United Kingdom, effort is sufficient, so-called sweat of the brow threshold exists. As mentioned, the United States does not have specific protection for databases. The European Union does, and the United Kingdom, by virtue of their prior membership of the European Union, also does. The core bits of legislation that we're talking about in the European setting are the software directive, the copyright directive, the database directive, the open data directive covering public sector information, and currently under consultation a proposed Data Act and a proposed Data Governance Act. Now, I've talked quite a lot about jurisdictional issues and how they vary in terms of their statutory formation. That brings up a really interesting question about choice of law. Choice of law indicates which national law should govern the interpretation of a license and related activities. In the first instance, the location of any allied server will determine the choice of law. But there has been a trend for public licenses to be international. In other words, governing law is not intentionally specified in the license text. The version for Creative Commons licenses are intentionally silent on which jurisdictional law would apply, and it's up for the parties involved to sort that out. You won't be able to read the slide, but if you later want to look at some of the definitions for data, for work, for a collection, and for a database, they're listed on the slide. These definitions derive from the official translation of the German Copyright Act. I want to just talk a little bit about legal uncertainty in the sense that there's a case on in France at the moment about covering software licensing, and it involves the GNU public license. That's the strong license family that I mentioned earlier. And there's an infringement case currently being litigated in France, but it's being litigated under contract law and not under copyright infringement. So again, this is a degree of uncertainty that the current statutory context has not resolved. To carry on with that theme, there is limited case law and very meagre statutory support, in which case there are very few robust conclusions about how these licenses will actually work in practice, particularly when there is some kind of infringement. Just recently, the US Supreme Court in Google versus Oracle America said that the use of APIs was actually fair use, but especially avoided the question of whether they were indeed protected under copyright. So that's sort of how the law plays out. Another unresolved issue is joint authorship. It's widely held that the contributor holds copyright to their own contributions, but there is evidence to suggest, or analysis to suggest that that is not correct, and that a joint authorship doctrine should apply. I'll talk about that in a moment. The legal lines concerning the various thresholds are vague as well. How much creativity is required, the line between a derived work and a new work, what constitutes fair use and fair dealing, what constitutes a substantial investment for a database in the European context, and what constitutes a substantial extraction, and what is the legal status of public sector information under European law. These are all unresolved issues, and it's quite problematic. Joint authorship applies to both code and data, and here is an alternative view based on the notion of joint authorship rather than individual contribution. This is quite a difficult slide, or complicated slide, but it's worth studying if you want to look at some of the kind of the landscape, I guess. The key issue is that code and data are treated separately under law, and there is a blurry zone, and it has a list of the various licenses that derive, and the various kind of architectures that derive. I'll just skip through that, I think. I was asked to talk a little bit about how you actually go about open licensing source code, and I'm going to kind of duck the question and refer to recent Free Software Foundation Europe good practice recommendations, because they will do a better job than I will here. But some key points: they use SPDX identifiers, add the full license text using a license.txt file in the root directory of your public repository, add license notices to all header files and all source files, while noting that you need not keep the copyright year range current if you don't wish to. Also to note that Git, for example, the version control system, does provide information, but its legal status also remains uncertain. The open licensing of data is, as I mentioned at the beginning, a shambles. And I would call on anybody with contacts with the European Commission to push for some kind of statutory resolution here. The first point is to use SPDX identifiers. There is some standards regarding legal metadata, notably the Dublin Core, which specifies the concept of a creator, the rights in the work, contributors, the license, and the rights holder. But these are very poorly resolved. What is a bit better resolved is that there's a touchstone definition for open data in the 2019 Open Data Directive, which is worth repeating, I think. Open data as a concept is generally understood to denote data in an open format that can be freely used, reused, and shared by anyone for any purpose. So that's a touchstone definition, and that's where we should be heading. The Creative Commons licenses that I am talking about later on fulfill that definition. The stumbling block for material in Europe, data in Europe, which is not open licensed, is the Database Directive 96/9 EC, which covers the European Economic Area. It's just uncertain as to whether a particular data set or database would attract database protection in this context, and whether a user can withdraw data from it and still retain the right to use that data. So the first thing to point out is that the legal definition of a database is very broad, much broader than any technical person would interpret, and it includes things like printed maps. And it's protected where the direct investment is substantial and the extraction is substantial. These substantiality principles derive from copyright law, but they're almost impossible for a user to determine. The directive was intended to provide support for a database industry in Europe, but it doesn't work in my view. Instead, material gets harvested and used to stock servers in the United States. For example, the World Resources Institute portal draws on the transparency platform. And as noted earlier, it provides legal uncertainty for risk-averse researchers in the absence of suitable open licenses. Public sector information may not be protected under the database directive. We don't know. Here is some legal analysis that suggests it is not, but again, that result is uncertain. Just to contrast briefly with the US Copyright Office, who state that the notion of technical databases being creative is largely mutually exclusive. Orthodox databases are highly structured, but they are not much selected and arranged. Non-orthodox databases, while not highly structured, are similarly even less likely to be selected and arranged. So in essence, the US does not have to deal with these problems because their legal context is different. Okay, so my pick for data licenses are the Creative Commons CC BY 4.0. For data, it imposes obligations for attribution and attribution tracking, which in itself is not, I don't think, a problem, because provenance needs to be tracked as well. And metadata should be pushed into the Creative Commons CC0 1.0, which is a public domain dedication, which falls back to a maximally permissive license in civil law jurisdictions like those in Germany and other parts of Europe. Interestingly enough, people, if you look through the literature, people who are interested in public interest information favor CC BY 4.0, and people who want minimum friction favor CC0 1.0 for raw data. I align with the people who are seeking public interest, because they're for them, attribution tracking and provenance are key issues. Just to reinforce on the very bottom square, in most cases, open data licenses do not provide permission, but rather offer certainty to users. Briefly, I want to talk about fair data principles, and I write, please treat this slide as a comment and not a criticism, but the fair data principles do not extend to open data. Specifically, R 1.1 says that metadata and data should be released with a clear and accessible data usage license, but it does not say that data usage license should be strictly open. So there's an extension to the FAIR principles with a /O on the end, where O indicates open licensed. Adding legal metadata to data and data sets introduces another range of challenges. The Dublin core for metadata was discussed earlier and provides some fields, but it was really intended for relatively static works like manuscripts and not for data sets that are widely combined and continually and subtly altered. So there are a whole raft of related issues that need to be confronted: data versioning, data alliance compliance, and the recording of provenance more generally. These are very significant issues. Most of them have been traversed by software and solved, at least to the level that energy system analysts require, but that same process has not occurred for data. Moreover, quite a lot of the solutions developed for code are unlikely to be readily transferable. The European Union is now currently consulting on the proposed Data Act, and these are speculative comments on my part, but I lead authored 2 public submissions on from the open energy modeling community. These are also hosted on Zenodo. Key aspects, as I read them, is that the European Commission wants to facilitate business to government B2G information transfers for public interest reasons. So I guess that makes sense. The 96/9 EC database directive is under scrutiny. It has been in the past as well too, and nothing has occurred. And at this juncture, and I don't have any inside information, but there's a little indication thus far if and how B2G transfers will be made more generally available, say to energy system analysts. So these are interesting questions. I want to talk about statutory reporting, and there are 2 substantial cases of concern, because one of the problems with statutory reporting is that it has not been made clear what kind of use is allowed. So the reporting is defined, but the context of use has not been defined, and this is a major failing. Data sets on the ENSO-E transparency platform are not open licensed, and members of the Open Energy Modeling Initiative have had long-standing dialogue with ENSO-E on this matter, including their legal department, but the matter remains unresolved, and it needs to be. The next statutory reporting is mandatory public disclosure by the European energy exchange, and they go out of their way to make sure that it's difficult to use. It's actually numerically unusable. Their web-based reporting is limited to human viewing, and highlighting and copying of the numerical text explicitly disabled. I'm not sure what mechanisms they use exactly, but probably cascading style sheets or JavaScript functionality. But in any case, the end result is that that numerical text cannot be picked up and used. There was some discussion in the last couple of months with ACER, the European Union Agency for the Cooperation of Energy Regulators, as to this practice, and ACER indicate that the practice is compliant. So both these issues need to be addressed, and I would hope they can be addressed at the statutory level. Quick quiz: is the Creative Commons CC BY 4.0 license a copyright license under copyright law, a contract under contract law, or it depends? And I pointed out that it depends. It depends on the jurisdiction. Okay, so to sum up, relative to open energy system analysis, there are no evident issues related to legal interpretation. There are certainly some, but in the context of energy system analysis, I think it's reasonably clear. The choice of license is well resolved in the absence of special considerations. Either choose low MIT or high AGPL 3.0 or later. The practicalities of licensing are sufficiently well resolved for projects to continue pretty much without problem. But contributor license agreements could be considered by some projects that they may offer some useful functionality. Relative to open energy systems, data is a shambles, the third time I've said that. The choice of license is well resolved. In the absence of special considerations, data should be CC BY 4.0, metadata CC0 1.0. But there are a whole lot of raft of issues. Interoperability with other licenses like for example, the Open Government License UK 3.0 needs analysis. Tooling to handle legal metadata and information provenance more generally is still in its infancy. Substantial work is needed on data semantics, ontologies, and metadata standards, and information under statutory reporting in the B2G to community data flows that could come out of the proposed Data Act remain unclear and are best addressed using legislative solutions, in my view. The last slide. So thanks for staying with it. Some readings. I just want to point out the second one down, Leon Hirt in Berlin wrote up very similar sentiments in the context of electricity rather than energy more generally. And you can download that paper and go through it. But again, it indicates how really what a sorry state the open data is for energy system modeling. I think that's all I want to do. Is Stephanie still here?
Yes, I'm still here.
Yeah, how do we want to proceed? We've got 15 participants. I guess I should stop sharing my screen and we can go from here. There's one mark and okay, that's just from you. Okay, so how do we want to run a discussion, or how do we want to carry on from here?
Well, if you want, we can make if there are any questions from the audience,
yeah.
we can open the Q&A session, or if someone wants to comment.
or else people can switch their microphones on and or video feeds and comment in person. That I think there was supposed to be quite a few more people at the session, and we've got 12 at the moment.
Yeah, and maybe just a note to everyone, you can, of course, feel free to start your video and speak out loud, or you can also always use the chat and ask your questions written.
There must be some questions out there. I don't believe that I ran through everything without prompting some queries or misunderstandings even.
Well, also, I mean, if there are no questions right now, I mean, for all the attendees, feel free to write Robbie a mail.
Yeah, sure.
I guess I'm just saying that right now, but if something pops up afterwards, and otherwise I would suggest if there's no follow-up, we can also close the session.
Yeah. Okay, well, let's give it a couple of minutes. Otherwise, people can head off and have a cup of coffee.
Hey, Robbie, it's Patrick. Hey.
Hi.
First of all, thanks for the nice talk. I was quite hesitant to ask any questions since it's a very difficult topic. Even if I stay with the topic for now, maybe 2, 3, 4 years, and will do so for another couple of years, it will remain a very difficult topic. And it was also a very broad presentation. You were addressing several different topics. So my main question basically always is how to transfer this knowledge into our daily work. So I really have a strong will to make things better for our institute, to adhere to the proposals you made, or which we can identify as being better than we have done before. What are concrete steps you would wish our domain would make in everyday work to make things easier for ourselves in the future, basically? So you are addressing the EU and different high-flying working groups. What can we do? What would you like us to do, basically?
Okay, first can I just turn the light on because I think that the light's faded outside. Okay. As I indicated, the situation for software is relatively straightforward and people have got comfortable with Git. I just say when I started, Git didn't exist and neither did Subversion. And I used a thing called CSV, but the first project I worked with had no revision control system, and it was about 30,000 source lines of C++. So that's that's how it was. So software is, I think, more or less sufficiently resolved for energy system analysts. But data is the big challenge. And my one comment on data is that it's a community process. It's not a project-based process or an institutional process. And I would like to see the Open Energy Modeling Initiative or the community associated work on all aspects of open data, not just the licensing. So that means semantics, ontologies, and metadata standards, just to start on that side. It also means things like community curation and how will that work. And it also means things like how some of the support can be automated, particularly regarding provenance And I have a short presentation on Thursday, looking to the horizon on open data as a community process. So that was, I know that's a very open-ended response, but it's the only one I can offer, I'm afraid.
Okay, thanks a lot. From our side, I can say that we have gained much awareness for these topics in the past. And I would say we are working or supporting all those directions you mentioned. But still, I'm always asking for concrete things, and I will keep doing so just in the future.
Well, I just mentioned a couple of projects because ERA Data have a project on metadata, which does not stray much into legal metadata, but it's trying to get some standards there. The Open Energy Ontology is working on ontologies for the for energy system analysis. There is not a single ontology. They're all a bit specific to the application and the domain. So that's an encouraging move. The Linux Foundation has some work on data architecture. I'm not sure how far that will go, but I'm peripherally involved in that. So a lot of the pieces are coming together, but I'm very keen that the European Commission looks more closely at the statutory aspects. And I submitted twice on the Data Act along those lines. Whether they will pick it up, I don't know. Who knows?
Okay, Robbie, thank you.
Okay, thank you for the question, Patrick. Anyone else like to switch their camera on and interact? Stephanie, shall we draw it to a conclusion?
I would also say if there are no other questions, maybe want to say some concluding words and we can finish the workshop.
Okay, I mean, my only real concluding comment, two comments. One is how ill-resolved data is, and the second thing is that I heard earlier today talks about transparency and so forth, and even open data, but these need really hard work to make progress on. We need to get down into the details and do some really hard work. So that's what's necessary. We need to roll up our sleeves. That's my last comment.
Thanks a lot, Robbie, and thanks for preparing this presentation, and everyone else for joining this session. I hope to see you also tomorrow and on Thursday for the other workshops and parallel sessions, and of course the plenaries. So have a good evening.
Thank you. I'm going to sign out.